Hi everyone. Today's lesson we are dealing with the criminal procedure, which is the most important and interesting part of our legal system. What I've done with this study unit, which is study unit 1, I've decided to simply divide it into 5 different aspects, where we will deal firstly with the place of a criminal procedure in the legal system, and the second one is the scope and context of the criminal procedure. The third one is the criminal procedure in the context of the Constitution, and the fourth one is the presumption of innocence in the context of a criminal procedure, and the last one is the inquisitorial, the different procedural systems. I am simply going to make differences between the inquisitorial system and the accusatorial system. I will unpack the differences there. So, starting off with the first aspect, which is the place of a criminal procedure in the legal system. In most legal systems, the legal systems use different procedures, which is the criminal procedure and the civil procedure. Both of these procedures have got their different sets of functions, proceedings, and procedures and consequences. So, if you were to take the criminal law, for example, the criminal law is a part of a substantive law. A substantive law is that body of legal rules that deals with determining the human conduct which are crimes, or it decides whether the human's conduct is a crime or not. So, in general, the criminal procedure is designed to essentially address and protect the public rights. And the civil procedure, on the other hand, is concerned with the vindication of the private or of the private rights. So, in a nutshell, it is a body that is followed, or is the legal steps that are followed after the crime has been committed. So, in general, the criminal procedure is simply dealing with the procedures from the initial arrest of the person. It's that procedure from the initial arrest, from the initial investigation, and up to the punishment if the accused is found guilty. So that is essentially the place of a criminal procedure in the legal system. And going to the second part, which is the scope and the content of the criminal procedure. The criminal procedure is essentially its job is to regulate the powers and functions of all criminal courts in the country. So this includes all functions, ancillary functions that are operating within the criminal justice system. And you are talking about the prosecution, you are talking about the duties and functions of the police, you are talking about the rights of the suspects, the arrested and the accused. You are talking about the pre-trial stage, for example, the bails. You are talking about the charge sheets. You are talking about the indictments. You are talking about the pleadings. You are talking about the actions in the trial stage. You are talking about the verdicts, the sentencing, and also, lastly, the closing stage of the trial. And what you must keep in mind is that during that process, the executive is also in part, or is also operating with the criminal procedure. So, in a nutshell, the scope and the context of a criminal procedure has essentially three basic functions. One, it functions to ensure that the material law is being followed, in a sense that there has to be an adjudication of the actions which are identified or described as crime by the statutory. And secondly, it ensures the legality. It ensures the legality in a sense that when the crime is committed, the body that is responsible for that, there has to be the establishment of a guilt, innocence, and the punishment. And lastly, it ensures the justice. It works to ensure that there is a justice, in a sense that the lawmakers are invariably obliged to ensure they make laws that are fair and thorough processes. Going to the third aspect, which is the criminal procedure in the context of the Constitution. On this aspect, simply we are looking at the supremacy of the Constitution. The Constitution is the supreme law, meaning that every single law that is inconsistent with the Constitution is invalid. So, with all the laws that we have, they all have to be consistent with the Constitution. The sections that are relevant in the Constitution is Section 8, which says the Bill of Rights apply to all rights, Section 8, subsection 1, and should have also written Section 35. Section 35 is the one that is providing for the accused persons. For example, I've stated in the previous paragraph that it speaks of the rights of the accused persons. It highlights that the person who is arrested has a right to remain silent. And I should have also included Section 35, Section 36, which is the limitation of rights, the limitation clause. That one also has a criteria. Some rights can be subjected to Section 36, can be limited under certain conditions. For example, the purpose of the limitation is to be stated, and that has to be done in an open and democratic manner, and also the extent of the limitation is to be clearly discussed for it to be successfully subjected to that right. And we go to the fourth aspect, which is the presumption of innocence in the context of the criminal procedure. This one has got three different groups that I'm going to unpack. The first one, which is the previous convictions. In terms of Section 210 or 11 of the Criminal Procedure Act, it states that when the accused is before the judge must not judge the person according to what the person has done previously. The person is to be judged for the crime that is before them. The second aspect we are looking is the presumption of innocence and the standard of proof. This essentially is saying that the person who is before the court, the prosecutor is the one that bears the onus to prove beyond a reasonable doubt the guilt of the person. So the prosecutor has to find all the elements of a crime, being the conduct, being the all of those elements of the crime must be established for the person to be charged. And the last one is the presumption of innocence and the principles of legality, that it has to be within the bounds of the principles of legality. And the last aspect, which is the inquisitorial and accusatorial procedural systems. In this one, we are simply looking at the different systems that we have. With the inquisitorial system is where you are having the judges leading the questions, ensuring that they are the ones that are questioning the litigants in the process, while the accusatorial procedure, where you find the judge are taking a passive role, they stand on the side while the litigants are fighting together with different evidence. The judges, the only thing they do is to prove with the evidence as to who has won and who failed the case. That is essentially the summary of Study Unit 1. In the next section, we'll be dealing with Study Unit 2. Thanks very much for watching.